Hello, my name is Laura Hudson and this is my criminal law final project. First part that we're going to go over is civil versus criminal law. The major differences being in a civil case, the plaintiff and his or her legal team is responsible for gathering the case and prosecuting the defendant. And in criminal law, the state and the prosecution is responsible. The victim's not responsible for compiling the case against the defendant. Another big difference is the burden of proof. In criminal cases, the burden is much higher. You have to be proven guilty beyond a reasonable doubt. And this is mostly due to the fact that criminal cases can result in probation, jail, or prison terms, and it can have also fines, and even in extreme cases, the death penalty, whereas civil cases rarely result in such extreme circumstances. Typically, they're just the requirement of having to pay a fine and or having to do or not do some action that they're currently doing that's resulted in a lawsuit. The next part we're going to go over is substantive versus procedural due process. Now these are both kind of different sides to the same goal. They're both with the purpose of ensuring that laws are fair all the way from the creation of them to the conviction and the processing and the sentencing of a defendant. Substantive is more on the side of creating the laws. Lawmakers and judicial systems will look at laws that are being created. They'll perform tests to make sure that the laws are fair to all people that are living in the United States, regardless of race or ethnicity or religion. Procedural laws are more on the side of enforcing the laws. They look at more the process of gathering a case against a defendant, warrants, imprisonment, questioning, jury trials, all that. But it's all the same process. It's all the same picture. They just look at it from two different sides and two different sides of the process. The next thing we're going to talk about is English common law and how it's affecting modern day laws. English common law originated in England in the Middle Ages. Lawmakers would look at the norms of the society and the morals of the people, and they would create common laws that were intended to protect the crown and for the good of the country. These laws were altered over hundreds of years, and they were brought over whenever the American colonies were formed. These laws were used in the colonies, and over time they were altered slightly to fit the needs of each colony. And then after the War of Independence, the American people were very resentful of anything that had to do with England and its laws, so most people in the United States just wanted to abolish common law altogether, and they wanted to create their own laws. And in some instances that happened, but judicial system and lawmakers understood how important common laws were and how they had a lot of validity being altered so much over hundreds of years. So a lot of common laws were made into statutes that could be enforced, and others were either modified to more common laws or they were abolished altogether. The next thing we're going to look at is constitutional law. Now, as the name suggests, it's derived from the United States Constitution. It kind of sets the standard for any laws that are created by the federal government, the state governments, or local government. It made sure that each of these laws aren't unfair or overly vague or violate any right that people of the United States have. It also relates to the different branches of the government, including the judicial system, the executive system, the branch, and the legislative branch. Now, statute law is one of the more common things that we discuss in criminal law. It's basically any statutes that are made. These are the most common ways of looking at law. These must adhere to constitutional standards. The Constitution sets the standards for these laws. And these are the ones that are often based in English common law. And English common law was kind of changed slightly and made a statute in different states. And statute law is often interpreted as cases are processed and convicted or not convicted. And also statutes can be addressed in any level of government. Now, case law is what you get whenever you try a statute against someone, and the decision that is found in that case becomes case law. And this is usually derived from cases that have not previously been tried, like different kinds of cases, or cases with very interesting circumstances. Case law is very important because it sets the standard. So if I'm convicted for murder for a certain set of standards, someone in 10 years will also be convicted because of my case. And, that ensures that there's not a lot of inconsistencies in laws, because that would obviously be very unfair. Now, the next thing is ex post facto laws. This is basically talking about making conduct that was made before a law was enacted criminal, and this is unlawful. It only deals with punitive type situations. It doesn't deal with things that are not meant to be punishments and just meant to promote safety, such as, like, I work for the sheriff's office, so I register sex offenders, and that's a thing I refer back to commonly because I know the different ins and outs of registrations. And basically, like, if it becomes illegal for a sex offender to live in a certain neighborhood because of the large amount of children, then they can be given a certain amount of time to relocate, but they can't be violated for living there before the law was created. But even though they were registered as a sex offender before this law came into effect, they can still be required to change their behaviors because it's for the good of the neighborhood. Now, there are restrictions for ex post facto laws in extreme circumstances and things like that. But as a general rule, conduct that was made before a law is enacted cannot be changed, nor can the degree be changed. It can't be changed from a misdemeanor to a felony, and then people convicted before have a felony now on their record. And it also can't change the degree of evidence that is required for a certain case. It can't be different or lessened or more. It has to be the same amount of evidence. Now, the burden of proof is very important, and I've learned that it can be divided into two sections. The first one is called the burden of production. This has to do with the initial making of the case. By law, the case has to meet certain requirements before it can even be brought to trial. And if the prosecution fails to meet their burden of production, then the defense can request for a automatic judgment basically in their favor, saying that there is no case made. The second one is the burden of persuasion. This is basically how the case is compiled and also how it is relayed to the jury. This will basically give you a guilty or an innocent verdict. You have to be very persuasive and have a very logical and full case in order to get that guilty verdict. Both of these different burdens must be met to have a complete burden of proof, and the prosecution is typically required to meet the entire burden. The next thing is elements of crime. True crimes, which are the majority, require both an actus reus, which is a guilty act, a wrongdoing, an unlawful act, and a mens rea, which is a guilty mind, basically the defendant knowing and understanding that what they're doing is wrong and unlawful. There are certain crimes that don't require a mental element, such as strict liability crimes, because they're seen as affecting the public welfare, not just one person. Some laws only need mental elements, and they don't need a guilty act, such as possessing burglary tools with the intent to commit a crime, whereas possessing burglary tools such as pry bars, hammers, ropes, duct tape, that's not a crime. You can buy these from Home Depot. But if they found that you have the intent to commit a crime, like you're casing a neighborhood or you're seen like checking windows, that kind of thing, then they can probably prove intent, and then you can be convicted just on the guilty mind. There are a lot of different defenses to crimes. It all depends on the circumstances. It's going to show which one that the defense will use to try to prove the innocence of their party. The first one I want to talk about is immunity. There's 3 different kinds of immunity. Diplomatic immunity is often granted to diplomats in other countries along with their families up until they're 21, or if their families are in school, 23. Then there's witness immunity. That will grant witnesses to crimes immunity either partially or fully based on the information that they have and the importance of it to the case. They'll be given immunity so that they can plead the Fifth Amendment and not give information that will incriminate themselves. They'll have immunity so that they cannot be prosecuted to anything they admit to when they're on the stand testifying for something else. And then you have legislative immunity. This is granted to U.S. senators and representatives while their legislative bodies are in session. They're still not immune to federal crimes like treason and things like that, and they're only immune while their legislative parties are in session. Sometimes they'll hold charges until the legislative body's out of session, and then they'll prosecute the representatives or the senators. So they're not completely immune, only during certain times and for certain things. Next thing is intoxication. Voluntary intoxication is very rare to be a successful defense, and generally it can only change a specific intent crime like murder to a general intent crime like manslaughter. So the charges may be lessened as long as the defense can prove that they were intoxicated or drugged to the point where their facilities and their judgment was severely impaired to where they could not have made a good decision. Involuntary intoxication, such as being roofied or drugged, or someone forcing you to take drugs, that can be a legitimate defense to a crime, and if proven and if the judge believes your story, that can excuse all crime. Duress is basically being forced to do an action that's criminal because of fear of imminent harm. This can only be imminent. It cannot be fear of future harm or a general threat. It has to be very intimidating and very imminent. Like if you say basically that I will kill your family 2 weeks from now, then you have time to go to the authorities. So it cannot be a duress defense at that point. Also, in cases of insanity or mental defect defenses, generally the defense is required to prove that. It's not on the prosecution to defend that this person is sane. Entrapment can be a situation where if the government entices someone who would normally never commit a crime to commit a crime because of certain circumstances. Decoys are a big debate issue in this, but because decoys do not entice non-criminals to become criminals, and they only tempt criminals to behave in a criminal manner, they're not considered entrapment. The last defense is acting under direction of another. So this defense will only work if you had no idea that your actions were illegal. It can't be that you weren't sure that this act was illegal, but you were planning on doing another act. And you have to have no idea that this was illegal, and you have to believe that whoever's telling you to do something would never entice you to do something illegal. So that defense is very strict, and it only applies to very small things. So this was the end of my presentation. I hope you enjoyed it. I know I enjoyed criminal law class. It's always been something I'm passionate about. Thank you for listening.